Okay, it's about 7:07 p.m. and it is now Monday, October the 11th, also known as Columbus Day, and to me personally, Christina's birthday. That's one of my kids. But anyway, um, welcome to week number 2. We're at week number 2 already. And after we finish this week, we'll be 1/3 of the way through. And I hope that I'm not going to go over what I covered in last week's open house, because I covered in detail some systems that you guys should pay close attention to. But I am going to get into some specifics this week. And probably the first thing that I want to get into is to check the messages. Great book. We'll get into that discussions. I want to get right into announcements. And the reason why I want to get right into announcements is because of this one. Last week, I mentioned it. This is a webinar that will help you with APA. And the first session that was started was last Tuesday, and that was library and learning resources. But the APA basics will take place. There's one tomorrow, October the 12th at 12:15 p.m. Central. For those of you on the East Coast, that would be 1:15 p.m. So I encourage you to go to that, even if you're okay with it, because they're going to give you some things that'll help you. And if you can't make it there, then Thursday at the same time, there will be one at 12:15. And then the APA advanced, dealing with more complex issues, which is something that you guys who are now heading toward your bachelor completer course would be interested in, will be a week from tomorrow at 12:15 p.m. Central. I do encourage you to go to those courses, webinars. I don't think they're recorded, but try to go to them, because they will give you a good start for the school year. So the announcement is going to be up until the 20th, but I do want to make sure that you would use this, because it'll help you with success as well. This week, we are going to deal with a topic that's called the exclusionary rule, the 14th Amendment. It's a tool that we lawyers, criminal defense lawyers, use quite frequently. And I'm going to talk about some of the material in the module in assisting me in getting this across to you. But in this announcement, it reminds you of Chapter 7 of the book. If you use Chapter 7 of the PowerPoints, it gives you a lot of good information about the 14th Amendment and the Constitution and the exclusionary rule. So be sure that you do your reading for Chapter 7 and use the PowerPoint that I sent you. And then there's some articles in there teaching the forgotten 14th Amendment and the Constitution of memory. Then there's the exclusionary rule, then 14th Amendment research starter, and the exclusionary rule research starter. These are some activities that I'll just touch on just a few minutes that will help you in terms of getting an understanding or an assignment completed for this week. Okay, very, very, very important. And the rest of the announcement is telling you where your lecture is. It tells you the discussion assignment. Again, exclusionary rule. Exclusionary rule is the topic of today. And so that's the discussion assignment, where the initial post is due tomorrow night, and the reply post is due on Saturday night. And then your written assignment, the U.S. Supreme Court and the exclusionary rule is due on Sunday at 11:59 p.m. Central Standard Time. And I'm going to talk about that assignment during the course of tonight. And you all already know about my motto, be strong and finish. You know about my motto, adversity is the springboard to success. I truly encourage my students to live by that and not be intimidated when you run into adversity. All right, so that's the announcements for week 2. I'm not going to go over the others because that we covered those during that week as well. I will go over and show you again, reminder. Let's do the month view of the calendar. This is where we are today, the live lecture. Your initial post, as I said, is due tomorrow. Your reply post is due Saturday. Your written assignment and live classroom lecture is due on Sunday. Okay, all right. So that's your schedule for this week. All right, let's go back into constitutional law. All right. So let's get into the module itself. The 14th Amendment and the exclusionary rule. The 14th Amendment and the exclusionary rule. And you have, as I said, you have your written assignment, the U.S. Supreme Court, and the exclusionary rule. Let's get into the written assignment. Go over that first for you to get that out of the way. So you have what we call due process under the 14th Amendment of the Constitution. And what that means is that you have an opportunity to gather information and evidence to prepare a defense to charges or allegations that are made against you in a criminal case. And your attorneys file what we call a motion for discovery. That is a document that's filed pre-trial to get the evidence that the prosecution has to substantiate the charges, whether it's information or either an indictment. And so when we go through that process, then we go through a series of motions. One of the most important motions that we lawyers use as defense lawyers is the motion to suppress. The motion to suppress. And what that motion is a document filed to exclude the use of evidence in a trial. So if a judge rules that the evidence obtained by the police was obtained illegally, a violation of the constitutional rights, whether it was they didn't obtain a warrant, or either that if they did obtain a warrant or that they still violated your 14th Amendment rights. And so you have a right to get that information cast out of the case. And that's what we're going to be talking about, the exclusionary rule. It is very, very, very important. Some say it's unfair, but no, because it's tied to the Constitution. The 14th Amendment for the states and the 5th Amendment for the federal government, so that you cannot be deprived of liberty without the law giving you a chance to defend yourself. Okay, so this written assignment that you're going to do here will examine 2 U.S. Supreme Court cases. The cases are given right here. You don't even have to go look for them. They're here. Now, then you want to discuss how these two Supreme Court cases are apply the exclusionary rule. And the cases are Hudson versus Michigan and Missouri versus McNeely. Now, if you clicked on the link here, it should open up the cases. I'm testing it to make sure that it's working for you. Yep. They're the facts of the case. Now, one of the things I do want to caution you is when you cite the case, the appropriate APA and proper citation for it is this one right here, 547 US 586. And what it stands for is that this is the volume of the United States Supreme Court book at page 586 where the case starts, and the case was handed down or decided in 2006. And this gives you the OYAs. Do not cite OYAs. Please do not cite oyas.org. Do not, I repeat, do not use the official court citation. Okay, very important that you utilize that. All right, so that's one case. And then the other is Missouri versus McNeely. So what you're going to do is you're going to take these two cases and you're going to summarize the facts of each case. Explain how the exclusionary rule was applied in each case. Identify how many of the exceptions may have applied to either case. I'm going to provide you with something that I developed that will help you with some exceptions to the exclusionary rule in terms of some cases, but this is just for your extra material that will help you. There's some in the PowerPoint, but I'm going to give it to you. Cite your sources in APA format, which means it's cover page, a reference page, and it's double spaced, okay? Use professional language, correct spelling, grammar, and so forth. And then these are some resources here that you have here. All right, so now let's look at the rubric. Okay, so now here's your rubric. Notice there are 4 columns. Anybody know what column that I want you to focus on? Type it, I'll see it. Anybody know what column of the rubric I want you to focus on? Thank you, Chris. Mastery. Hear me well. I sound like a broken record when I do this, but I still keep doing it. It is important for you to maximize your grades to get A and B. The way that you do that is by focusing on the column to the left, mastery, advanced. That's an A. Proficiency is a B. Competency is CD, and then emerging is F. So you don't want to even look over here. You don't want to even look on that side. I wish I could delete it, which I could if I wanted to throw it in the garbage, but I'm not, because they said don't do that. Because they want you to know that if you didn't get this, you're going to get either this, this, or this, and then your feedback is really going to be in the body right here. Here's the feedback. So if you got competence in the summary of the case, it's because you got competence is an adequate summary of the case with minimal details demonstrating understanding of the significance of the case. Excuse me. Then if you don't have any of that, you're going to get this. And then I might tell you with a little brief remark under details under the bottom of the section. But the point of the matter is, this is very important. So For this case, outstanding summary of the case and comprehensive details demonstrating a thorough understanding of the significance of the case. The next aspect is an outstanding summary with comprehensive details demonstrating a thorough understanding of the significance of the case. And why they have two in here, I don't know, but that's what they did. So, oh, I know why. Okay, that's because that's the second case. My bad. I was reading over on this column. But yeah, so this is for Hudson, and this is for the Missouri case. All right, McNeely. Same thing. So you got to do that for both cases. My suggestion is some of you might know how to brief a case, and you might want to brief a case. That's not necessarily what's going to be in the assignment. But if you really wanted to really demonstrate something as an appendix, you can put an appendix to this assignment as a case brief of the issue. You can do that, but that's going to be an additional thing. That'll help you out a bit with understanding the case. Exclusionary rule. Okay, this is the key issue. An outstanding explanation of the exclusionary rule and how it applied in each case, demonstrating a thorough understanding. And then exceptions. Outstanding identification of the exceptions to the exclusionary rule that may have been applied. Provide that. Again, cite your sources. And there it is right there. And then professional language. All right. That's it for that assignment. Now, anybody have any questions about this assignment? Please type in the chat box if you have questions. Okay. All right. So everybody's straight. Good. That's my goal, to make sure that you don't have a misunderstanding about this. Incidentally, how many pages should this paper be? 3 to 5. There you go. If you go beyond 5, it's okay. If you go under 3, then you're gonna see a comment that takes you out of exemplary. Okay. All right. Very important. Very important. All right. All right. Let me move this. Get out of that. Okay. Let's close that. Okay. Then you have the discussion post that is due tomorrow night. And I see a few responses already in here. For this discussion, you're going to discuss the exclusionary rule, which the exclusionary rule, and apply it to a real world scenario. Here's the scenario. You don't have to make up a real world scenario. Right here, given. So your initial post, explain the exclusionary rule. I already kind of broke it down for you already, but I'm going to go into more detail before we adjourn tonight. Discuss how the rule applies to this scenario and justify your answers. If the exclusionary rule applies, what are the ramifications? What is accomplished? What does the exclusionary rule accomplish? I already told you that. And support your comments with sound legal arguments. I know those when I see those. I'm almost be like the judge in this case here. And you're the attorneys who presenting the evidence. I had a student one time say to me, why do you're an attorney, why do you make us grade us on that same way? I said, no, I grade you on following the instructions and the information. You don't realize how smart you are in terms of becoming an attorney till you go to law school sometimes, but it's not that hard. It's a lot of work, but it's not that hard. Trust me. I take that because if I did it, anyone can do it. So I recommend it to everybody. And then so you're going to reply to at least one other post, all right, and discuss your peers' responses. So this is an exciting week for me with this topic here. I love this issue because it's bread and butter. Any questions about the discussion post? Wait a minute, I see something in the chat that Amber is saying. I have a doubt whenever possible. Okay, no rush. I don't know what that means. Is that something you're saying you need to talk to me later about? Okay, you call me right after class, as soon as we finish. Okay, you got the number, so do that. Be happy to. It's probably something that you're overthinking, but anyway, you're gonna be okay. All right. So, any questions about the assignment? Yes, probably is right. I know you pretty well, Amber. Okay. Okay. Mr. Presley or Pastor Presley, if you don't mind me saying that. And anybody else? Okay. Then your live classroom uh, submission. Of course, you're going to submit that, and you know when that is due. And that is due for your 5 points. You can do that tonight before you leave here, and you can just fill that in here, hit submit, and then you'll have that completed and out of the way. All right. I'm laughing because anyway, you'll see why I'm really laughing at the end of the class. And then here's the link to get to me right now. But then, of course, that's going to be changed to the actual recording. Okay. So let's talk about the 14th Amendment. The 14th Amendment of the Constitution just basically, it's lengthy, but the main thing that affects what we're dealing with is Section 1. Section 1. And it came in 1868, after the Civil War, to establish Black American civil rights. And Section 1 is the one that we use for due process issues. And it's the main focus of our topics that we discuss in criminal law. Sections 2, 3, 4, 5 are discussed below, but I'm not going to spend time on them because they have to do with issues unrelated to our assignments here. They are constitutional, but not. So let's read. All persons born or naturalized in the United States and subject to the jurisdiction are citizens of the United States and the state wherein they reside. Now, here's where we get to the due process aspects of it. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, nor shall any state deprive a person of life. That's where the death penalty comes in, or somebody being killed. Liberty, that's putting you behind bars, or seizing your property without due process of law. And I already explained due process. Due process of law is a concept that deals pretty much with your rights to provide an opportunity to defend yourself. So you get, anybody saw the movie My Cousin Vinny? Did you see the movie My Cousin Vinny? Well, if you haven't seen it, you see it. But here's what happened in that movie, and this is based on reality. And that's why, and it applies to our assignment here, is that And then the prosecution had evidence against the attorney's clients, and he did not know that he could ask the attorney for that information. There was a book that Melissa Torme, who was his girlfriend, it was called Disclosure, and she was explaining to him that the prosecution must disclose any evidence, and that you can question the witnesses or potential parties that would be testifying in the trial and the criminal case. Now, they can't, on the other hand, come back and question the defendant. That's the only person that the prosecution cannot. So you both can talk to each other's witnesses except the defendant. Okay. Now, the point of the matter is that when that information is obtained by filing that motion for disclosure or discovery that I mentioned earlier, then the prosecution has to return that information over. If the prosecution withholds what we call exculpatory evidence, and what exculpatory evidence is any evidence that would benefit the defense. Let's say, for example, the prosecution is aware that, for example, okay, let me give you an example. They produce pictures of bullet holes in a door and provide that to you. However, they also have information that they're aware of, that those bullet holes that they actually tried to use as evidence were in fact nail heads, and they withheld that evidence, which is exculpatory for the defendant. Everybody gets my point? Okay. So the point of the matter is that they have to release that. So then it says, without due process of law, nor deny any person within its jurisdiction equal protection. In other words, everybody should be equally afforded that opportunity. So that's what I'm going to say. That's what the 14th Amendment. Now, remember this. The 14th Amendment applies. Notice what it says. You see it in here more than once. Who it applies to states. It doesn't say federal government. It says states. The 5th Amendment of the Constitution, if you take a look at that, you will see it applies to the federal government. So what the 14th Amendment did was, when it came in 1868, is that it brought the application of the laws of the federal government in to be applied from every state. All right. So we're not going to get into all of this. I'm going to focus on this part right here, the due process part. So again, it kind of says what it does that I already said. This section forbids any state from depriving any person of life, liberty, or property without due process of law, which is found in the 5th Amendment. I just told you that. And it refers to any person, which means all people on American soil, including those here illegally. So that applies to illegal immigrants if we're dealing with the laws of the United States. James Madison, who was a secretary of, actually a president, but before that he held another position, was compassionate about the 5th Amendment and the right of trial by jury. And I, as a lawyer, can tell you that I'm a fan of jury trials. I tried cases frequently before juries because I felt we had a better chance of adequate defense provided from 12 citizens in the box who would listen to the testimony and deal with the evidence that comes across in the courtroom. So it was not until the 14th Amendment, which required equal protection of the law for all citizens, that the employment of selective enforcement of amendment provisions came. So the due process is what we call, and I remember this phrase, fundamental fairness. It's fundamentally fair that it be applied in all legal proceedings. Okay, so I've talked about that, the 14th Amendment. So now you got a clear understanding of that. Now let's talk about a tool that we lawyers love as defense attorneys, called the exclusionary rule. So you have to be familiar with this, because if you are not familiar with it, then you might violate the rights of a person when you place them in custody or under arrest. And this gives an example here. A tipster reports David Brown is selling cocaine from their house at 1234 Main Street. And you've suspected that David has been doing that, but you've not been able to prove it. But you believe that your anonymous tip is needed to finally get David's house searched. So a couple police officers come to the door and knock on David's door. He says, I'm not going to allow you to search my house. Now, with this anonymous tip in mind, all the officers enter the residence, and a search reveals cocaine. I'm the defense lawyer representing David. Man, I got my bib on. I got my knife and fork sharpened up, and all of the cocaine that they recovered is going to be tossed out. Every bit of it. Every bit. Anybody have any ideas why, before I go into the details? Well, yes. Okay, you're going to discover that you have to have a warrant in instances, except there is an exception to obtaining a warrant. The officers did not have a warrant, did they? Did the officers have a warrant? Nope. Now, one of the exceptions, and I'll just tip it to you right now, for obtaining a warrant is what they tried to do, and that they asked David if they could search David's house. David said, "Get out of here. Get out of here." But the police went and did it anyway. And then it says in our comments, although it is well established that information obtained from anonymous tipsters is questionable at best, you believe you are on solid ground. And the reason why you cannot use this is because of the fact that you did not get consent from David or have a warrant. Okay? We've talked about what due process is all about. So when defendants are accused of committing a crime, they have a right to discover. I already told you by the discovery process. I told you that all the evidence against them, including how the evidence was discovered or collected. And it must be, let me look at this word here, legally obtained. Legally obtained. Okay? The exclusionary rule says it forbids illegally seized evidence from being used at trial, with the exceptions. And I already told you we would talk about that. And we're going to deal with the exclusionary rule, and it's a check and balance. So it came originally from two cases: the old landmark case of Weeks versus United States, a 1914 case, and Mapp versus Ohio. And you have a discussion of each of these here. And I'm not going to go over the details. But in the Weeks case, just as a thumbnail, the search was unlawful and the evidence should not have been seized that used against Fremont because the court applied the rule to the federal authorities because the U.S. Marshal was involved. So this was dealing with the, obviously, the Fifth Amendment, if we're dealing with that. But anyway, the point of the matter is that the exclusionary rule did not apply to state officers at that time, but it applied only to federal officers. But Weeks changed with the coming of the 14th Amendment. All right. So he was suspected of being a person who had illegally mailed coupons or tickets dealing with lottery or gifts and so forth. And he was prosecuted in federal court, and he wanted his property back. But the court said, well, if the search violated the 14th Amendment, and if so, should the evidence be permitted at trial? The court said the search was unlawful and seized and should not have been used because of the violation of the amendment. Okay. Due process rights. Everybody with me so far? Okay. These are foundational cases. Mapp versus Ohio brought it to the 14th Amendment, the states. So the previous one was dealing with the federal government. And so if you notice what happened, and I'm very familiar with this case, oh my God, even though it happened in 1961. And by the way, remember when you cite these cases, cite the original full citation in your papers. Miss Mapp, she was suspected of hiding a bomber inside her home in Cleveland. But was arrested for possession of lewd and lascivious books, pictures, and photographs. So she told the police the same thing David said, you can't come in. And she phoned her attorney. Officers returned and forced entry into her home, and they wouldn't allow the attorney to come in. She demanded to see a search warrant, and the officers held up an alleged search warrant, which it wasn't. It wasn't. She snatched it from his hands and tried to conceal it on her person, and the officers struggled and retrieved the warrant and handcuffed her. And they continued the search. The suspected supposed bomber was not found. So there was no warrant. She was convicted anyway. The state believed that Wolf versus Colorado, which was a 49 case, permitted the evidence to be admitted. And so in that case, the Supreme Court analyzed if states were required to exclude illegally seized under 14th Amendment. And at that point, the answer was no. But she was convicted. Ms. Mapp was convicted and lost on appeal. And she appealed to the Supreme Court, who granted certiorari. Just when you see that term certiorari, what that means is the court agrees to hear the case. That's what it really means. And notice what happened. In a unanimous decision, the court agreed with Ms. Mapp that her 14th Amendment rights prohibiting unreasonable search and seizure were violated. Therefore, the evidence should not have been used against her during the trial. Okay, let's see what you're asking. Yeah, yeah. Yes, I do. Whenever I say cite the sources, and that's a good question, Sylvester. Very good question, but the answer is absolutely, positively, yes. Okay. And so the case was reversed. And the case was reversed and remanded back to the state court. So what happens is the Supreme Court said, you violated her 14th Amendment rights. Therefore, we're going to send it back to you to give you another chance to do this without using that same evidence. The case was reversed and remanded, and it applied the exclusionary rules to the states after that, which have been applied many times. And the infamous Miranda versus Arizona case applied the rule to improperly obtain confessions, which I've talked about that before. My former law professor techniques were used in that Miranda versus Arizona case, and the Supreme Court said they were unconstitutional, and he took offense to it. But I've talked about that before. But the exclusionary rule also helps prevent law enforcement officers from breaking the law. Law enforcement should be led by example. If law enforcement breaks the law, it can be problematic for us. So the key thing is this, is that the law is in place to cause the law enforcement individuals to respect the rights of individuals. Okay? Any questions about that? Any questions? You should be an expert on this doctrine because of the things that I've shared with you, just basic stuff. So now there's a doctrine called fruit of the poisonous tree. Now, this is, of course they are. Of course they are. That's why we lawyers still file motions to suppress, to exclude, and we apply the exclusionary rule going back to Mapp versus Ohio, and the prodigy of cases. I'm going to give you some other cases later that will help you. But yes, absolutely. That's what, man, I specialized in those kinds of things. That was one of the first things we did. Here's what we did. We said, police, law enforcement, if you're going to make a case, you got to make it following the Constitution. And the Supreme Court said, yes, you can't bring in illegally seized evidence that violate the 14th Amendment and the Fifth Amendment if it's in federal court. So that's the essence of it. And somebody said, but that's unfair. No, it's not. I can tell you this, guys. I've represented some law enforcement officers before, and they can tell you, they said, oh man, at the time when I was doing my job, I never thought that it would be valuable right for me, but it's the right for everybody. Everybody, everybody, everybody. This is foundational stuff, guys. So the exclusionary rule also prevents any evidence obtained from being used. I already told you that. And the reason why it is because that evidence is what we call the fruit of the poisonous tree. The fruit of the poisonous tree. And it came in a 1920 case. In this case, evidence was obtained pursuant to an unconstitutional search and seizure, kind of like David's earlier that we talked about. And any evidence, listen to this, critical statement, any evidence obtained from the unconstitutional search or seizure could not be introduced in court, no matter how good it was. That could be a video, that could be a picture, that could be statements obtained in violation, like Miranda. It could be a search where you went too far, as if you know about the what's the name of the other case? Terry versus Ohio. Anybody know that case, Terry versus Ohio? It's also known as the famous stop and frisk case, where you went too far there. So it says, any fruit of a crime obtained from an unlawful search or seizure cannot be used in a criminal proceeding. So if the police violate the Fifth Amendment right, the right to remain silent, or the Sixth Amendment right, where the person does something before they have an attorney. We talked about this before. During a custodial interrogation, any information obtained during that interrogation cannot be used. But remember, the way it works, it's not automatic. It's my job as a defense lawyer to file the appropriate motion to challenge and have a separate hearing before trial. And once that evidence is ruled on, if the judge agrees that it was a violation of the fruit of the poisonous tree doctrine and the exclusionary rule, then the prosecution cannot bring it up. If they do, what can happen? Anybody know? There you go. There you go. Right on, Sam. I'm sorry, that's said, Sam. Is Sam okay for Samantha? Every Sam. Oh, Sam is okay. Perfect. On point. Exactly. Couldn't have said it better myself. You see, you guys are already on your way to law school. You didn't realize it. But uh, based upon what you learned in this lesson, uh, can the evidence in our scenario be used against David? I already answered that, so you don't have to answer it. No, I told you up front you can't. And now you know why as well. Although the exclusionary rule is a powerful deterrent to unlawful improper policing tactics and serves as a check and balance between law enforcement and the courts, there are a few exceptions. And you will learn about those exceptions to the exclusionary rule. I'm going to go into those in just a few minutes. All right, we got just a few minutes to go to. But there's some additional resources. This is such an exciting lecture to me because you could tell I'm excited because it brings me back to my courtroom days. So there are exceptions to the exclusionary rule. Okay, and here they are. Right here. You are a dedicated and proactive police officer in your community. In your downtime, you often try to find wanted suspects or subjects. One day, while searching through your warrant base, you locate a man known to you from prior contacts as John Smith, and the date of birth is January 1st, 95. So with that knowledge of the warrant, and you and another travel to John's house and contact John and say, "Hey, John, um, uh, you are under arrest." John says, no, what? No way. It's a mistake." Although John is upset, he does not resist and is handcuffed without incident. Now, listen. Upon searching, you find a small bundle of suspected methamphetamine, which tested positive because it was methamphetamine. Before you transport him to jail, the warrant, you realize there was a mistake. The date of birth was January 1st, 1995. I'm sorry, January 10th, 1995, and not 01/01/95. You looked into it further and discovered you made a mistake. The warrant was for somebody else named John Smith. Can the seized evidence pursuant to a mistaken warrant be used against John in court? All right. That's something that I'm going to provide you with some information on. But here are some references that will help you to come to that answer. Okay. Now, let me show you something. It should open up what I'm going to tell you. Okay. Exceptions to the exclusionary rule. This is a little exercise that will help you with that last fact pattern. Okay. So I know you couldn't hear what I heard, but there are four doctrines. So now, um, these four doctrines, one of these are going to be established exceptions. And you can, and you're going to, and I'm not going to stay with you later, but I'm going to have you to go and take a look at, just briefly, the good faith exception. Okay. Now, just based on that, what you listed earned, let's go. I want to go to the next one. Let's go. This thing is not working right. Okay, so now based on what you know about the good faith exception, do you think that will stand based upon that error in that number as an exception? Okay. All right. Anybody else? That's a good guess. Anybody else? The answer is possibly. That's what I'm going to tell you right now. Okay. We'll see. Let's do the next one because I'm only giving you some of it. And you can't hear what I'm hearing because I got my headphones on. I don't think, can you hear what this lady is saying? So the point that you should know from that one is very simply, if it had been inevitably discovered, I keep going back and forth. I have to do that because, okay. Okay, so now let's go to the inevitable. So in other words, the key thing is, by preponderance of the evidence, would that have been found as an independent source? Okay, let's try the inevitable because y'all are. So the key thing in that case is that if it could have been discovered by other means. So does that kind of like support the position that that you get that you guys have said? Does that kind of help you out there? When you go through and research this a little more, you're going to find out some interesting things. But I think you all are on the right track. And then the last one, the attenuation doctrine. Okay, let me see what Amber said, and we're a little over, but I'm about to end. But the good faith doctrine states that it has to do with an existent warrant, and the police thought there was one that was valid. Okay. You know, the neat part about it is everything that you guys have done, you can present arguments. That's the beautiful part about the law. And we all have done it. And that's how the law gets changed. So the answer is you're on the right track. You're on the right track. Okay. You could be part right and part wrong. At this point, I'm just going to leave it right there. I'm going to supply you with some other information. And so the last thing, and you go back and look at that and listen to what she says too as well, because you couldn't hear it, I don't think, on my, since I had my headset on. This is a practice thing to help you as well. The right to pass freely from state to state to petition Congress for redress of grievances and the right to vote are examples of what? Anybody know? We didn't really go into it, but privileges and immunities. I didn't really get into it. Okay, but that's the answer. What is the landmark case that first established the exclusionary rule? Anybody who gets this one wrong, flunk the course. Nobody's going to answer, right? Come on. Which one is it? Everybody's scared. Huh? No. Yes. Yes, Sam. Weeks. Okay, let me help you out. Oh, now easy for everybody to say. Miranda had to do with confessions interrogation, but it didn't come first. Arizona versus Gant. I'm not going to tell you about that, but I'm going to supply you with some information regarding that. Gideon versus Wainwright is the Sixth Amendment right to an attorney. It's Weeks. Remember the 1914 case? Miranda writes, was Miranda. Gideon versus Wainwright, court-appointed attorneys, and Gant, search of via automobiles. But I'm going to give you some, I'm sending you some information as soon as this class is over. So look for that. Okay. So anyway, those are just last one. I can't resist doing this one. I cannot resist it. The exclusionary rule prohibits any evidence obtained from the unlawfully seized evidence from being used at trial is known as what? Awesome. That's exactly right. Okay. So anyway, I'm gonna leave you all alone now. I'm gonna let you go. But I hope that you totally got it. I enjoy doing this lecture because it's awesome. So I'm gonna give one guess for the key phrase for today. It's the exclusionary rule. How many times did I mention the exclusionary rule? You lost contact. If you go back and count, that is what we talked about the whole time. Yeah, we talked about some of these other things. We talked about the poisonous tree as going with the exclusionary rule. And Brian says, well, I, I don't know, was that a well, like in church well? Is that one of those tune-up wells? Because I know you can sing. Is that what that was? You know, like, well, okay, all right. Okay, guys, I'm over my time, but God, I could already hear. I've already heard some of your messages, and you've heard mine, and so we kind of have that thing in common. I could, without hearing you, I could already, you know that that's the case. So, well, that's your tune up as you close. As I close for the third time, it's the old preacher's thing. So, all right, guys, I'm gonna say good night to you. I will see you next Monday at the same time. I hope that you know, um, you learned a lot today. I hope that you got some valuable information. You should be prime time for these assignments after this lecture. So I try. Okay. Good night, guys. See you guys next week. Amber, call me.